Hello friends, today we are going to discuss the answers of questions of Indian polity of IAS pre 2021. Nature of questions of Indian polity were not very difficult in examination. We can say the level of difficulty was moderate in examinations, and questions were based on concept and fact both. Overall, questions were very good. The whole paper was very good, but we are focused here only on the topic of Indian polity. Therefore, we will discuss the question of Indian polity only. So, as per Indian polity is concerned, the questions of Indian polity were very good and not very difficult in nature. So, let us start with first question of the paper. So, first question was, and this was the first question. Under the Indian Constitution, concentration of wealth violates. Very easy, very simple. It is a direct question from Article 39 clause small b and Article 39 clause small c related to directive principles of state policy. We know very well. These articles are related to DPSPs, directive principles of state policy. And Article 39 small b is related to equitable distribution of wealth. And Article 39 small c is related to prevention of concentration of wealth in harmful hands. So both articles, Article 39 small b and Article 39 small c, both articles are related to distributive justice of the Constitution. The concept of distributive justice have been adopted in our Constitution, and this concept is given in Article 39 B and 39C. 39B is related to distribution of wealth, and it emphasizes equitable distribution of wealth. And Article 39C says that state shall ensure the prevention of concentration of wealth in harmful hands. So the question is, under the Indian Constitution, concentration of wealth violates. So concentration of wealth violates Article 39 small b and 39 is Article small c. So 39 clause b, 39 clause c, small clause b, small clause c, and these are related to DPSP. So the answer is DPSP. Very simple question. It was very easy question. Next question. What is the position of right to property in India? We know that right to property was fundamental right before 1978, but after 1978, that is after 44th constitutional amendment, now it is legal right and constitutional right. So this is legal right, and this right is available to any person according to the language of Article 300 clause A, clause capital A. This article is related to right to property, and this article says that no person shall be deprived of right to property without authority of law. So this right is given to all persons, not only to citizens. So answer is B. Here answer is B. Very simple question. Very simple question. It was very easy question. And third question, most easy question. Most easy question. What was the exact constitutional status of India on 26 January 1950? You know very well. Sovereign democratic republic. This is the answer. Because preamble describes the nature of polity, And the nature of polity which is mentioned in preamble is sovereign, socialist, secular, democratic, and republic. But we know that socialist and secular nature was added by 42nd constitutional amendment. But in original constitution, there were only three words mentioned in preamble: sovereign, democratic, and republic. So it is very simple, very easy question. It was very easy question. So the answer is B. Fourth question: constitutional government means. This is conceptual question. What is the meaning of constitutional government? Constitutionalism, constitutional government, constitutional morality. These are very fashionable words in these times. So questions are asked from this section, and these concepts, we discussed these concepts in early lecture when we start the lecture of Indian polity. Then we will discuss all the concepts: what is government, what is governance, what is state, what is administration, what is constitution, what is constitutionalism, what is constitutional government, what is constitutional morality, and many more concepts we discussed already in class. So, what is constitutional government? Constitutional government means the constitution, the government which has limited authority, and the authority is limited by constitution. That is, government always functions under the provisions of the constitution. What does it mean? It means that constitution decides, constitution describes the do's and don'ts of the government. Always constitution describes the do's and don'ts of the government. So what government does, it is described by constitution, and what government should not do, it is also described by constitution. So constitution describes do's and don'ts. So the constitutional government means the government limited by the terms of constitution. Very easy question, very easy question, and very simple question. The first option is a representative government of nation with federal structure. No. Government whose head enjoys nominal power. No, it is parliamentary. A government whose head enjoys real power. No, it is presidential form of government. And a representative government, it is representative democracy. So constitutional government is government with limited powers, and the powers are limited by constitution. So this is the fourth question. Very simple question, very easy question. The next question is: consider the following statements in respect of Bharat Ratna and Padma awards. Bharat Ratna and Padma awards are titled under Article 18, Clause 1 of the Constitution. So these are titled. It is said here. It is not titled. It is not titled. It is award. It is a kind of award. It is a prize. So it is not title. We know what is the difference between title and prize. So it is not title. And we have to find here which is not correct. Not correct. Okay. So the first option is not. Second, Padma Award, which were instituted in year 1954, were suspended once. No doubt, this award was instituted. What started in 1954. It is true, but it was suspended only once. It is wrong. It was suspended many times. During 1977 to 1979, it was suspended. During 1993 to 1997, it was suspended. So it was not suspended only once. So this is also wrong, not correct. The number of Bharat Ratna award is restricted to maximum number of 5 in a particular year. No, the number is 3. The number is 3. It is restricted to the maximum number of 3 in a particular year. So this statement is also not correct. So we have to find here that which statements are not correct. So all these three statements are not correct. So our answer is D here. Our answer is D here. 1, 2, 3. All these statements are not correct. This is the fifth question. Now, sixth question. We can see the questions are very easy in nature. With reference to India, consider the following statement. Judicial custody means an accused is in the custody of concerned magistrate and such accused is locked up in police station, not in jail. So we know that if any accused is arrested by police, then police seeks police custody, and the accused always wants judicial custody. So two type of custodies are there. We know that in police custody, the person is locked up in police station under the custody of police. So it is police. It is known as police custody. But in judicial custody, the person, the accused, is not locked up in police station. It is put in jail basically. It is put in jail under the custody of magistrate. What is the meaning of under the custody of magistrate? The meaning of under the custody of magistrate, that is without the prior permission of court, without the prior permission of magistrate, police cannot interrogate such person. And during interrogation, a legal representative may be present there. So the question is, judicial custody means an accused is in the custody of concerned magistrate. Yes, it is true. And such accused is locked up in police station. No, it is not correct. It is not correct. Such accused is locked up in jail, not in police station. So one is not correct. Uh, we have to find here which of the statement is or correct. So this is not correct. This is not correct. Second option is during judicial, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Yes, it is true. This is the basic difference between police custody and judicial custody. So second statement is correct. So our answer is B. Answer is B. Because second statement is correct and first statement is not correct. Okay, so this is the uh, sixth question. Now, next question, seventh question. With reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. So the question is about parole, that is jail manual, that is the management of jail. The management of jail is related to uh, magistrate power, executive magistrate power. The executive magistrate is head of jail management of the district. So decision related to parole is taken by district magistrate with prior consent of the state government. So decisions related to parole is vested in district magistrate and state government. So what is parole? We know that what is parole, bail. These are concepts we will discuss later on in any separate video. What are these concepts and when these um, privileges, that is parole, bail, for law, can be given by authorities. So this question is related to parole. A prisoner can be released by jail authorities on parole when the conduct of such accused or such prisoner has been good in jail on the basis of good conduct for the fulfillment of his social need, he can be released on parole. So parole can be given to such prisoner. But when he seeks for parole, then it is his privilege. It is not his right. He cannot demand parole as right because parole is not right. Parole is only a privilege. Uh, Conceptually, parole is privilege. Conceptually, it is privilege, but in many cases, court has also declared it that parole is only privilege. So it is not matter of right. So first statement is wrong. It is wrong. The second statement is state government have their own prisoners release on parole rule. Yes, of course, because the management of prisons, jail is under state list. Is under state list. So state are authorized. There is prisoners law in our country which was made in British period, and under that law, all states are authorized to make their own rules, and states have made their own rules for the management of jails, for the management of prisons. Therefore, um, state governments have their own rules. So the second statement is correct. That is, the answer is B. The answer is B here. This was the seventh question. Now, the eighth question. Eighth question, very simple, based on fact only, no concept is there. At the national level, which ministry is nodal agency to ensure effective implementation of the scheduled tribes and other traditional forest dwellers recognition of Forest Right Act 2006? So all rights, all rules, laws, etc., which are related to scheduled tribes are under the purview of Ministry of Tribal Affairs. So the answer is B, that is Ministry of Tribal Affairs. So it is factual question, fact-based question. Now, ninth question, very good question. It was a legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law violates which one of the following articles of the Constitution of India? 14, 28, 32, 44. Very simple option is, and the option is Article 14. Why? Why it is 14? Article 14. Two reasons are there. First, the unguided and uncontrolled discretionary powers are related to rule of are against to rule of law, are against to rule of law, and rule of law is vested in Article 14. And in the case of EP Royappa, there is a guideline of the Supreme Court. I have discussed this case in our notes, and also I have mentioned this case in our polity book. EP Royappa. EP Royappa case is there. EP Royappa versus State of Tamil Nadu. It is a leading case of Article 14. And in this case, the case of EP Royappa versus State of Tamil Nadu, Supreme Court said that arbitrariness is enemy to Article 14, is enemy to right to equality. So both are against to each other. Arbitrariness and right to equality. Both are against to each other. So unguided and uncontrolled discretionary power means arbitrariness. Unguided and uncontrolled discretionary power means arbitrariness. And in case of EP Royappa, Supreme Court clearly declared that arbitrariness is against Article 14. So it violates Article 14. So it is against rule of law. And also, in case of Ipiroyappa, Supreme Court has clearly stated that it is a very leading case. Supreme Court clearly stated that arbitrariness is against Article 14. So it is Article 14. Article 14. A very good question. And also it was very simple in nature. It was ninth question. Now, 10th question. Very simple. Most simple question is this. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? So we discuss what are the federal features of Indian Constitution, what are unitary features of Indian Constitution. We have already enlisted in the class. What are the federal features and what are the unitary features? So independent judiciary is federal feature. It is the most prominent. It is the most prominent federal feature because in federal character of a state, powers are divided between center and provinces. And if there would be any dispute between center and province, then there should be a separate and independent judiciary for resolution of such disputes. Therefore, in our constitution, under Article 131, which is known as original jurisdiction of Supreme Court, in this article, that is under the original jurisdiction of Supreme Court, the Supreme Court has been vested with the power of resolution of disputes between center and state. So independent judiciary is most prominent feature of federal character. So the answer is independence of judiciary. Very simple question. It is very simple question. We cannot expect so simple question from UPSC, but UPSC has asked these type of simplest question in exam. So the question paper was very simple. Uh, Now 11th question. Very simple question is this also. Which one of the following best defines the term state? When we start studying polity, then we discuss what is state, what is nation, what is government, what is governance, what is administration, what is constitution, what is constitutionalism, what is constitutional morality, what is constitutional government, and many more concepts we discussed already in our first lecture. So, what is state? It is very basic question and simplest form of question. Most simple question is. So you know that any territory which has a certain amount of population and government and also sovereignty of government, then that territory is known as state. So four elements of states are there. Territory should be there, population, that is people must be there, government, also there should be a government for the fulfillment of goals of people and for the resolution of disputes of people, and also government must enjoy sovereignty. So these are four elements of state. We know very well. And if we read all four statements, a community of persons permanently occupying a definite territory, independent of external control. Independent of external control means sovereignty, and possessing an organized government. So the first option is our answer. Second, politically organized people, no, not at all. Natural. A number of persons who have been living in definite territory for a very long time for their own culture. No, culture is not element of state. A society permanent living in definite territory with central authority and executive responsibility, central authority, independent judiciary. No, it is not definite. So the correct answer is very simple question. Question is very simple. 12th question. With reference to Indian judiciary, consider the following statements. Any retired judge of Supreme Court of India can be called back to sit and act as Supreme Court judge by Chief Justice of India with prior permission of President of India. It is the question is related to structure of Supreme Court. When we discuss the structure of Supreme Court, then we discuss the appointment of judges, the appointment of acting CGI, the appointment of ad hoc judges in Supreme Court, and also the appointment of retired judges in Supreme Court. So these all are related to the structure of Supreme Court. So Article 128, this statement is related to Article 128. If there is no availability of judges for the completion of quorum of Supreme Court and ad hoc judges are not uh, ad hoc judges cannot be appointed, then the Chief Justice of Supreme Court can request to any retired judge of Supreme Court to sit and to work in Supreme Court with prior permission of President. So this is Article 128. The option is correct. Correct. And second statement is the High Court in India has power to review its own judgment as the Supreme Court does. Yes, we know that. The power of review of judgment by Supreme Court is given under Article 137 in the Constitution. But for High Court, no separate article is mentioned for review of its judgment. No separate article is mentioned for High Court, but separate article is mentioned for Supreme Court. But we know that High Court is court of record under Article 215 and Article 226. Under Article 226, High Court has a wide range of discretionary power of issuing writs. Therefore, being a court of record, every court, being a court of record, every court has a right to review its own judgment. That is, when any court is designated as court of record, when any court is designated as court of record, then such court can also enjoy the power of review of its judgment. Therefore, because High Court is court of record, High Court is court of record, therefore, High Court is court of record, it is mentioned in Article 215 in the Constitution. Because High Court is court of record, therefore, under Article 226, High Court has its discretionary power to review its own judgment. So the second option is correct, but it is not given in Constitution, but it is as per the designation of court of record. So both answers, both statements are correct in this question. So answer is C, both 1 and C. 1 and C. Now, it was a good question. Now, 13th questions. 13th question. With reference to India, consider the following statements. There is only one citizenship and one domicile. Yes, correct. We have adopted unitary nature of unitary features of Constitution. Some unitary features of Constitution. So one, this is one feature of unitary Constitution in our country. So first answer is correct. First statement is correct. First statement is correct, not answer. A citizen, second statement is a citizen by birth only can become the head of the state. No, not at all. In America, a citizen by birth only can become a head of the state, not in our country. In our country, any citizen of India, whether he has adopted the citizenship by birth or not, is eligible to become the head of a state. So in our country, citizenship by birth is not essential feature to become the head of a state. It is the essential feature for America. So second answer is incorrect. Second statement is incorrect. So it is not correct statement as per India is concerned. It is correct. First statement is correct. Third statement is a foreigner once granted the citizenship cannot be deprived of it under any circumstances. No, it is wrong. It is not correct because if any foreigner acquires citizenship by registration or by naturalization, then there are some grounds mentioned in Citizenship Act 1955 on which these citizenship such foreigner can be deprived of from his citizenship which he has been acquired which was acquired by such person from by registration or naturalization. So he can be deprived of citizenship. So third statement is not correct. Only one statement is correct. One. So answer is A. Our answer is A. One only. Good question. 14th question. Very simple question, but conceptual, but very simple question. Which one of the following factors constitute the best safeguard of liberty in liberal democracy? Best safeguard of liberty. So very simple question. The concept is related to separation of power because the concept of separation of powers was given by Montesquieu, French thinker Montesquieu, and in his book The Spirit of Law, Montesquieu describes the concept of um, separation of powers. That is, the concept was described by Montesquieu uh, only to safeguard the liberty. To safeguard the liberty, this concept was propounded by Montesquieu. Separation of powers was propounded by Montesquieu to safeguard the liberty. So it is the uh, basic principle. It is the basic doctrine of any liberal democracy to safeguard the liberty. The answer is separation of power. To safeguard the liberty, it was the reason behind the development of concept of separation of power by Montesquieu. So the answer is D. Very simple question. 15th question. 15th question. We adopted parliamentary democracy based on British model, but how does our model differ from that model? Good question. As regards legislation, the British Parliament is supreme. Yes, British Parliament is supreme or sovereign. But in India, the power of Parliament is the power of Parliament to legislate is limited. Yes, of course. In India, the power of Parliament to legislate is limited, and it is limited by Constitution because Constitution describes do's and don'ts for government, for Parliament, and for judiciary. So in India, it is limited. First statement is correct. Second, in India, matters related to constitutionality of the amendment of an act of parliament are referred to the constitution bench by Supreme Court. Yes, it is also correct because when there is a question of constitutionality of any act or amendment of act and the matter um, is pending before Supreme Court, then Supreme Court refers this matter to the constitution bench for final decision. So this is correct. So both statements are. The answer is C. Both 1 and C. Both 1 and 2 are correct. This is 15th question. Now, the 16th question. Gopalaswamy Iyengar Committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reform and promoting it. This question is not related to constitution. This is related to Indian administrative system. So the question is related to public administration. Basically, it is related to departments of Government of India. So Gopalaswamy Iyengar was a member of Constituent Assembly. He was bureaucrat basically, and after independence, a committee was set up under the chairmanship of Gopalaswamy Iyengar for the reorganization of administrative system. And in 1949, the committee made its some recommendation. But the recommendation of committee was not related to such type of administrative reform. It was related to only reorganization of department, that is portfolio system. So uh, the Gopalaswamy Iyengar Committee was not related to such type of recommendation. So answer statement 1 is not correct. It is wrong. It is wrong. This type of suggestions were considered by first administrative reforms. Basically, in 1970, the Department of Personnel was constituted. Yes, it is correct. It was 1970. On the recommendation of Administrative Reform Commission, 1966. Yes, is also correct. And this was placed under the Prime Minister's charge. Yes, it was administratively placed under the Cabinet Secretariat. Cabinet Secretariat. But politically, it was placed under Prime Minister's charge. And also at present, it is under Prime Minister's charge because in 1985, it was given full-fledged ministry. The Department of Personnel was declared as full-fledged ministry in 1985. But in 1970, when it was established as department, so it was a department only under the Cabinet Secretariat, and Cabinet Secretariat is always under the Prime Minister's charge. Therefore, second statement is correct. Second statement is correct. So first is not correct, second is correct. That is the answer is B. 2 only. The answer is B. Seventeenth question. Very simple question. Most simple question. The right to privacy is protected under which article of the Constitution? Under the judgment in the judgment of K.S. Puttaswamy versus Union of India. K.S. Puttaswamy was judge in Tamil Nadu. So, in the case of K.S. Puttaswamy versus Union of India, Supreme Court has declared that right to privacy is fundamental right under Article 21. So, very simple question. Very simple question. And 18th question. 18th question. Yes, it is very technical, related to it is related to fact only and related to very technical facts. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. The statement is wrong. Before 1996, there was no such law. But in 1996, RPA, Representation of People Act 1951, was amended. RPA 1951 was amended in 1996, and Section 33 is related to valid nomination. Section 33 of RPA Act is related to valid nomination, and the clause 7 of this section clause 7 of this section was added in 1996, and it prohibits any candidate from contesting in one Lok Sabha election from more than two constituencies. So any candidate can contest only from two constituencies, not more than two. So this is not correct. This is wrong. Next, in 1991 Lok Sabha election, Shri Devilal contested from three Lok Sabha constituencies. Yes, this statement is correct. This statement is correct because earlier he had contested from two constituencies, and in 1991 he had contested from three Lok Sabha constituencies. It was before 1996. So the statement is correct. Third, as per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him or her in the event of him or her winning in all the constituencies. Very progressive thought. It is a very progressive thought uh, given by Election Commission, but it is not correct right now in our country. It is related to electoral reform, and it, uh, it will be a very good incident if we make a reform in such way that the cost of by-election shall be um, bear by political parties. But at present, this thought is only thought. It is not in existence. The third option is not correct. Third statement is not correct. It is thought only. So only one statement is correct. That is two. So option is B. Option is B. Only the statement two is correct. And the last question, 19 questions were there in polity. So the last question is the Montagu-Chelmsford reform of 1919 recommended granting voting rights to all women above the age of 21. Yes, there was recommendation for voting rights of women in Montagu-Chelmsford reform, but not for all women. Not for all women. Not for all. There were certain limitations over these rights. Therefore, the answer is not correct. The statement is not correct because it was not related to all women. No doubt, right was given in Act 1999, which was based on Montagu reform. In Act of 1919, women were awarded right to vote, but under certain limitations, and not this right was not given to all women. So first statement is not correct. I have written this statement in my polity book. The Government of India Act 1935 gave women reserved seats in legislature. Yes, of course, because during British period, many seats were reserved for communal awards for Muslims, Sikhs, Dalits, uh, women, etc. So in 1935, some seats were reserved also for women in state in legislature. So second statement is correct. Second statement is correct. First statement is not correct. So the answer is B. Only two. Only two. So these are overall questions. 19 questions were asked in polity, and we have seen some questions were very easy in nature, and no doubt paper was very good and questions of Indian polity were very good. Hope you will be able to understand what is the answer of various questions and how the answer is. What is the correct explanation of each answer? So we have discussed here the question answer of IAS pre-exam only for polity. Only for polity. For main examination, what are important topics and which topic we should cover for this year, we will discuss in another video. For this video, thank you.